Okay, I think it's time for us to get started. So welcome to the webinar. Everyone is on mute and in listen only mode. This webinar is being recorded and the recording will be available at fraudfighters.net/office hours. So if you have questions, please type them into the Q&A box. It is at the center bottom of your screen. And check off the Ask Anonymously option if you would like to remain anonymous. If you enter your questions into the chat option, then your identity or the pseudonym that you're using is visible to everyone on the call or the panelists. So the attorneys on this call are not providing legal advice. The information provided on this call is for general purposes only. And without further ado, we welcome you to our monthly office hours with whistleblower attorneys Renée and Eva.
Thank you, Q. Hi, Eva.
Hi, Renee.
So as Q said, welcome to our office hours. I'm Renee Brooker.
And I'm Eva Ganasikera.
So it's nice to have everybody join us today. We are happy to answer questions, and we have a lot of callers or listeners to today's webinar, if that's what you call it. Our office,
Renee. It's office hours.
Our office hours. We hate to say webinars. So feel free to, again, as Q said, questions should go in the Q&A box. And we have we've gotten a lot of questions ahead of time. So we're gonna try to address a lot of the ones that came in before this, but we will continue to look in the Q&A box and be happy to address any questions or comments that folks have. So thank you for joining us. And I'm just going to introduce Eva and myself and tell you just a little bit about ourselves. We work here in Washington, D.C. for a plaintiff's public interest law firm. And we exclusively represent whistleblowers in whistleblower reward cases in whistleblower reward programs. We work on contingency, so we don't get paid if we don't recover for a whistleblower. And we file cases in all 94 federal district courts in the United States. And we work with all 92 United States attorneys' offices in the United States. So even though we are located physically and live here in the nation's capital, we really do work with cases and clients all over the country. In fact, I don't think we actually have a single client in Washington, D.C. or Maryland. All of our clients are, all over the country. We have clients in California, and we have clients in Minnesota, Colorado, several clients in Florida. So we really do have a national practice and are very familiar with all the local practices. And we have a lot of partner firms in all of those jurisdictions.
So what Renee is saying is that her Rolodex is long and full of federal and state prosecutors who we've worked with throughout our entire career on these types of cases.
And so Eva and I like to talk a little bit about how we came to know each other and how it is that we work together, because you will see us working a lot of our cases together and doing a lot of speaking engagements together, and there is a history there, and it has to do with whistleblowers. So Eva and I have probably been working together for about 15 years or more.
Oh my gosh, has it been that long?
It's been a long time. I know you're tired of me now.
Could never be. Could never be.
We're like a little bit like sisters or partners in crime, as we sometimes like to think of ourselves. And
sisters who are, just a couple decades apart.
And you can't tell which of us is older.
That's right.
So we started working together at the Department of Justice here in Washington, working with our partners around, our law enforcement partners around the country. And we did a long trial together in representing a group of whistleblowers against a national healthcare provider. And we were in trial in the South, and the trial was 3 months, and it was hot as hell in the South where we were.
Oh yeah.
And we were
in full suits every day.
Every day we sweated walking from our hotel to court. Since we worked for the government, we didn't get to take a limousine or a cab. we walked with our rolling carts every single day across town. And we were really passionate about the case and the trial that we were involved in, because it involved some pretty pernicious conduct against a healthcare provider. And the jury that we had was really impressive. And even I learned a lot about human nature, I think, from that jury trial, which I think that's sort of a basic thing that you learn when you're an attorney who does trials. Is we have a lot of respect for the jury system, and the jurors in that case put in a lot of sweat and tears into that trial and deliberated for several weeks. And the judge even sent them back to the drawing board more than once after they rendered their verdict to do some more work, and they did. And so you spend 3 months in the heat in a suit, not seeing the light of day for 3 months. You get to really know a person.
You do. And you either come out of that and you hate them, or you come out of that and they feel like family. And so for Renee and I, it was really the latter. We were in the trenches together. And Renee really, at the time, was actually my supervisor, because Renee was a former assistant director in the department at the Department of Justice that enforces the types of cases that we're going to talk to you about today. So she was my boss. And notwithstanding the fact that she
and
was
now Eve is my boss.
yeah, right. Now we're equal. But notwithstanding the fact that she was, the supervisor of our trial team, she stuck with us every single day, and that really, frankly, was a lifesaver when you're going through an experience like that and you're trying to seek justice in a case that was, just as Renee said, really pernicious fraud. And that's part of what we want to talk to you about today. And really, it's a story that just hasn't been told enough. And so many people go through these types of experiences and they don't really even realize what happened until after the fact. And so we're hoping to shed some light on that.
So what are whistleblower reward programs? We get asked that a lot. And recently we spoke to a group of employment lawyers. And the first question we had, but if you remember this, Eva, before we even got started, is a lawyer said, some people call themselves False Claims Act lawyers and some call themselves key tam lawyers. Is that the same thing, or are those two different things? So we're going to cover that and other really basic questions. And again, from the initial line of questions that we got prior to today, we have developed some of our thoughts that we're going to share with you based on the questions, the incoming questions that we got in advance. So
before you get started, Renee, I think we have our first question. The question is, when I press on the accelerator, my car makes this sound, chugga, chugga, chugga. It's a 1982 Subaru. The guy at my local garage says I need a new transmission. What do you think, Renee?
Well, yes, we are click and clack.
We'd love to be, but the click and clack of the whistleblower reward programs. So
this is not car talk.
We can't help you with your 1982 Subaru, but if you are aware that 1982 Subaru has some kind of unlawful exhaust or a defective part, and you receive that car through your government employment, then you can come talk to us.
Or there's a lot of transportation cases do make good potential False Claims Act cases, and there's a new whistleblower reward program that addresses transportation issues. And the government contracts, both federal and state governments contract with transportation companies. So you could, if you are an employee of a transportation company and you know that your employer is doing something shady involving the government contracts because they are not complying with the contract terms, or they are not following the rules and regulations set out by the government, you could potentially be an employee whistleblower of a transportation company that does business with the government. So Thank you for that question. And we're going to cover at a high level. We're going to talk about primarily today, there are many different types of whistleblower reward programs, and we can certainly cover all of them, and we do in many of our seminars. But today we're going to mostly talk about the False Claims Act, but I think to just, tell our listeners at a high level, there are other whistleblower reward programs other than the False Claims Act. Many of them, but not all of them, are centered around different kinds of financial fraud. So there is the DOJ bank fraud whistleblower reward program, known as FIREA. There's the CFTC whistleblower reward program. So if you are someone who has knowledge of commodities fraud, commodities trading, futures trading, you could potentially receive a reward under the CFTC program. Same thing for SEC whistleblowers. If you have inside information about a SEC violation or some kind of financial fraud, you could possibly receive a reward for good information from the SEC. There's also an IRS whistleblower program for tax fraud. And the Treasury Department has a fairly new anti-money laundering whistleblower program. So we could spend a lot of time today talking about all of those, but we're going to just really at a high level today, unless we have questions about those other programs. We're going to talk about the False Claims Act, and we're going to talk about how a company violates it and who can violate it, because we often get asked that question as well, and who can be a False Claims Act whistleblower. And those are really just some sort of high level topics, and we'll get a little tiny bit into the nitty gritty, but we don't want to get too deep in the weeds. We kind of want to stay at a general level because you can really get a little bit too esoteric or specific about these topics. And if you're getting too specific, you may want to reach out to an attorney to ask more specific questions that apply to your situation.
Yeah, I think that actually segues perfectly with another question that we received, which is what types of questions should I ask myself if I think I've observed something that would be fraudulent? Should I go straight to an attorney?
Well, that is a great question. So I guess we would respond in a couple ways. It depends in part, the questions that you ask yourself depends in part, and assuming that you are an employee of a company and you're questioning or have concerns about what your company or your employer is doing, you may ask yourself different questions based on whether you work for a healthcare provider or a government contractor. And as Eva and I always say, the False Claims Act has incredibly broad applicability. Any industry that does business with the government, either directly or indirectly, and we can give a couple examples of what we mean by indirectly, but any industry that does business in any way or has to follow rules and requirements of the federal government or state government is subject to False Claims Act liability. And that is pretty much almost every industry that you can think of. So the healthcare industry is incredibly broad. When you think of the healthcare industry, you think of hospitals, physician provider practices.
And just to break that down, Renee, I mean, when you think of healthcare, we're not just talking about contracts that a hospital may have with a government agency to provide healthcare. We're actually talking about, in large part, the largest insurance provider in the United States, which is the Medicare and Medicaid programs. When people think of Medicare or Medicaid beneficiaries, there's not always an appreciation that those programs are funded with government money. And almost every healthcare provider is a Medicare and or Medicaid provider, meaning that they receive that money when they perform services for those patients. And so that really, to me, frankly, when I entered this space 15 plus years ago, was news to me. I was never really appreciating the fact that the Medicare and Medicaid programs are health insurance. And so it's money that the government is paying, and they're paying that money with the expectation that a healthcare entity or a manufacturer of drugs or devices is providing a certain service in exchange for that money. So it's a huge swath of people. But just as Renee was saying, the False Claims Act touches on every industry, which was another less known fact to me when thinking about who is defrauded in this space. It's really, unfortunately, every federal and state agency who disperses funds in some way, which can be highways, it can be small business, it can be financial services, it can be grants, it can be the Department of Education. It runs the gamut.
So I think, thank you, Eva. I think if we get back a little bit to the question that the person asked, which is, what types of questions should I ask myself? So if you work for a healthcare, let's just focus on the healthcare industry. We can move to government contracts, but if you work for a pharmaceutical company, a big laboratory, a hospital, a physician practice group, a managed care organization, anything, really any employer that you may have in the healthcare industry, you want to ask yourself, do I have concerns about my employer's compliance with federal rules and regulations? And do I have any concerns about how patients, either directly or indirectly, are being handled and addressed? And so even I can give some, sort of different examples, but even as I said, when I say directly and indirectly, for example, one easy example is big pharmaceutical companies. They manufacture, sell, and market drugs, and they sell and market them to Medicare and Medicaid patients. And as Eva is always famous for reminding me, Medicare is the largest health insurer in the country. So they are an insurance program, and they too, just like any private insurance company, have rules and regulations. They have coverage, and you have to comply with the rules and regulations. So even if a big pharmaceutical company does not have a patient, right, they are selling and marketing and manufacturing drugs to patients, which are prescribed by physicians, which are filled at the counter at pharmacy. They're not actually seeing patients or directly handling and dealing with patients, but they are subject to the False Claims Act, because if they violate any rules and regulations, they can cause a false claim by virtue of the violation of the rule or regulation, the Medicare rule or regulation. They can cause a false claim to be submitted by a doctor or a pharmacist or a hospital or another entity or individual in the healthcare space. So they too are subject to the False Claims Act. And the purpose of the False Claims Act is several-fold. One, and I always think the primary purpose of the False Claims Act is to give back to the taxpayer program, the taxpayer-funded program like the Medicare and Medicaid program in the healthcare space, to give back the money to the program that was fraudulently taken or that was taken in violation of regulations by anyone in the healthcare industry. And that is one big purpose of the False Claims Act. It is to hold accountable healthcare providers and healthcare entities in that space to ensure that they do comply with the rules and the regulations, and that they are properly treating patients, and that they are dealing with the rules and regulations as they should be. And also making sure that they protect patients, because many, maybe not all, but most probably False Claims Act cases have some direct or indirect patient harm involved. And so it's for protection of the actual insurance program to continue to have it be solvent. And, Medicare is not a bottomless pit. It's funded mostly by taxpayers like you and me, and everyone who's listening to this call. And so the government has this great enforcement tool to protect it, but it's also to protect whistleblowers and to encourage whistleblowers to step up. And whistleblowers are primarily, but not exclusively, employees who work at some, at a healthcare company in the healthcare space. So in order to encourage a whistleblower to stick their neck out and report fraud to the Department of Justice and to, bring their case to an attorney in the first instance, the government has is like a carrot and stick approach. So the government is dangling a potential reward. If you have good information and the government acts on your good information, then you are entitled to a whistleblower reward. It also protects whistleblowers in that it prevents retaliation by your employer. So there are protections under the False Claims Act if your employer does retaliate against you because you are raising your hand and you are speaking up at your company. And so a lot of people come to us because they have spoken up repeatedly inside their company and they've been retaliated against, which doesn't necessarily mean you've been fired. You could have been demoted or ignored or marginalized,
Or
you
forced
could have
out.
quit. Yeah, you could have
Forced
quit
out. Mhm.
because you saw the writing on the wall and because there were other things that happened to you. I mean, sometimes it could be something as simple as being, put in the basement office, or your work and your responsibilities have been marginalized, and in effect you've been forced out, and so you don't actually need to be fired by your employer to be considered retaliated against. So those
That
are
was
sort of
super helpful. Thank you,
some of the
Renee. Yeah.
right,
Super,
even some
super
of the
helpful.
really
Yeah.
big
And
points.
I put us in a healthcare mindset, but really a very close second, and an area that frankly needs more enforcement efforts in more recent years is government contracting, and more specifically, Department of Defense type fraud. DOD contracts are astronomical. We're talking billions of dollars. And we're talking about, really one of the more important components of the government, our national security, military, and law enforcement. And an easy example that you may have read about, to the extent that you've seen any of these types of headlines, is the bulletproof vest litigation, where the government was being sold bulletproof vests that, surprise, weren't bulletproof. So that took the form of a False Claims Act case, and was brought by whistleblowers who took it upon themselves to bring to the government information about how these vests were not being manufactured consistent with what was promised to the government. So these types of cases come in many different forms. And I think, just to bring it back to that question, because of the complexity and the different layers that we're talking about, ultimately, if you have observed and have documentary evidence of what you believe is just suspect behavior, or frankly something shady, it may behoove you to just pick up the phone and talk to an attorney, but not necessarily any attorney, an attorney who practices in this space. And we're always open, Renee and I, to speaking, and we do. We speak to dozens and dozens and dozens of folks on a weekly basis who are vetting their concerns with us. And we take that very seriously, because fraud is a serious allegation. And you definitely need to have some awareness of what to look for.
And as Eva said, and someone asked us, are all False Claims Act attorneys the same? And I guess I would answer as I would if you asked me that question about, doctors. Are all doctors the same? No, of course not, because attorneys and physicians have different types of training, different background, different experiences. And you really want to make sure that you have gone to an attorney who has deep experience in and specializes in False Claims Act enforcement and has somewhat of a track record in this space. No different than if, I myself would, if I'm seeking tax advice, I'm not going to call Eva. And Eva's not going to call me, even though we're lawyers and we both took tax in law school.
I respect you, Renee. No, I'm not going to do it.
We're not going to call each other for tax law. We're not going to call each other for, in fact, I didn't do my own will. I had somebody else do that because that's not my area of expertise. You also, if you need a specialist, physician, you're not going to go to the wrong specialist. And so I do think that it's important that you find a False Claims Act attorney who has, deep experience in the space, knows how to work with the Department of Justice, because it is a partnership with the Department of Justice. It is very helpful, of course, if you've worked at the Department of Justice enforcing the False Claims Act. It's not necessary, but it is very helpful.
Well, it's looking behind the curtain. It's like you're in Oz and you get to look behind the curtain and see how the sausage is being made. And that's, invaluable insight that can't be duplicated in just private practice attorney space. So yes, I would say that's like a must in a False Claims Act attorney to some extent.
So, and you also, I think you want to be comfortable with your attorney, right, Eva? I mean, one of the things that, you know, we love our clients. We have great relationships with them. On occasion, we meet somebody who brings us a case and we don't think it's going to be a good relationship. We see a little bit of oil and water there. We are going to recommend that they go somewhere else, and we actually might give them a list of other names. You really have to be comfortable and trust the attorney. It's a relationship, just really frankly no different than, you know, you would like to have a good relationship with your primary care physician, someone who you think cares about you. When you walk in their office, they're not flustered, they, you know, forgetting who you were. They don't remember you from office visit to office visit. You don't want that kind of a relationship. You also want an attorney who's going to pick up the phone when you call or email or text and make the time for you. So really, I think I would just recommend that you take the same care in looking for an attorney for a False Claims Act case as you would finding an attorney for, you know, finding a financial advisor or finding an attorney for
finding a
physician
or a specialist for, you know, if you end up, you know, in an unfortunate place with a specialty diagnosis, you're not just going to open the yellow pages and go to whoever's around the corner. You're going to take your time to
yellow pages.
I know.
Eva, you're dating yourself.
I can't believe it.
Now they know which of us is older. They know now.
I revealed myself. So we have another good question. What if I know about a fraud scheme, but as part of my job, I did something that was part of the scheme? Can I still bring a case and be a meritorious whistleblower, basically?
And I'll answer this how I hear Eva answer this all the time, because we get asked this question commonly, and Eva always says, and actually I won't even quote you, Eva, because I'll quote a prosecutor at a meeting that we had a year or two ago, where the whistleblower at the meeting with the prosecutor was clearly hesitant and holding back. And the prosecutor said, if you were involved in the fraud scheme, you're probably better, you know, a better witness for me than if you weren't. So I can tell you're holding out on me. And, you know, to be a good whistleblower, you have to know information about the fraud scheme. So very few people who have information about the fraud scheme are like outsiders, right? The whole point is that you were involved in some way. And
you were put into an uncomfortable position. Many instances, we have folks who come and tell us, I was doing this, and at some point, something clicked in my head that maybe I shouldn't be doing this. So they may have even been engaged in the fraud for months, years, and not appreciating. And this kind of goes back to, you're in your lane. You can only know kind of what's in your lane, which is why seeking counsel with a False Claims Act specialist attorney or a whistleblower rewards program specialist attorney is important, because they're able to have that more objective view of, this was wrong and this is why. And it's good that you came to me once the light bulb went off.
Yeah. And I was just, I'm thinking about a client that we had recently who met with the government, and the prosecutor asked, you know, when you were, you know, kind of involved in all of this for a number of years, when did it occur to you that this wasn't right? And the client said, it was during a conference when a physician confronted my boss, who was standing next to me at the conference, and really gave it to my boss and laid out what he thought the fraud scheme was, and it literally hit me like a ton of bricks, and almost like scared the hell out of me. And then I was like, holy cow, I really hadn't, like, it opened my eyes, and I called an attorney. And you know, he said he just really hadn't, you know, hadn't hit him in the way that you know, until he heard that conversation with the doctor and his boss. And then he realized what his boss was doing was wrong. You know, he said he had thought like something didn't seem right, but then he realized like, wow, this is not right. So there's all different reasons why you may be in the middle of it. And lots of times, you know, most people working are not, the first time they see something, going to go run and find a lawyer, right? It's just not what you do. You try to work it out, you try to figure it out, You try to, confront, even if it's not like direct confrontation. And a lot of our clients actually try to fix the system. We have a client who said that they spent like 8 years literally thinking that they were going to be the panacea that fixed the big problem that they were seeing. But then when things really got bad and they said, like, now I feel like this is like outright fraud, then they were fired. But they had all along tried internally to fix the problem. So, as I said, there's very few whistleblowers who are completely on the outside of the fraud. That's why they're whistleblowers, and that's why they're good whistleblowers, because they have some inside information and some insight into what was happening. So that's something you need to be very, very forthcoming with your attorney about, your False Claims Act attorney, and you will talk it through, and you will come up with a good way to have that conversation with the prosecutor team. But that should not deter you from stepping up. What is worse is, knowing that you've reached that point where you're like, now I know this is wrong, and just walking away from it. That's not the best. That's not the best path forward. So you really kind of want to step up and get someone else's opinion, and see what your legal options are.
Exactly, which actually brings us a perfect segue to the next question of, okay, so I've observed fraud in the workplace, or I've observed fraud with a co-worker or a co-company that we work with, because as Renee has said a couple times now, you don't always have to be an insider. I think sometimes when we think of a whistleblower, it's always someone on the inside, but we have worked with really fantastic whistleblowers who were on the outside, either third-party vendors or sometimes even competitors who observe fraudulent things and just bad practices or shady acts that they want to report on. And so again, you can be a whistleblower wearing any of those hats, but you've decided, you've observed it, you have suspicions, you think something's up. What if you only have a few documents to support your allegation, or you think you only have a few documents to support it?
This is a big topic that Eva and I talk about every day.
Yes.
Because we talk to people and they have more, what hard evidence they have is not necessarily what they think they have. So, there's very few, sometimes there is, but very, very few cases where there is some, smoking gun, like a text or an email where your boss says, like, I know I'm submitting false Medicare claims, believe me alone. That just doesn't happen. But whatever documents that you do have, I guess there's two types of employees that come to us. They're former employees who've already left the company that committed the fraud, and they're current employees who are still there. They're thinking about leaving. They've been retaliated against. They often call us, and they're still at the company. So if you have already left the company, then you clearly have only the documents that you brought with you.
Right.
So it's what is important to the Department of Justice is they do like to see hard evidence. So they love documents. So you can't bury them with too many documents. If you come with 1 million pages of documents, the DOJ loves it, and they're going to look at all of them, and they're going to have better basis for evaluating and investigating your case, and we will have a better, stronger case to move forward with your case. And
well, that's the crux of it. I mean, civil prosecution of these types of whistleblower programs rests on documents. Yes, there can be anecdotal evidence. Yes, there are occasional witnesses who come forward and provide testimony, but that's not sufficient. You prove these civil violations and these wrongs on the government with the documents. I mean, it's really the only way to do it. Now, with that said, and Renee included this, if you already left, then you're really kind of left with whatever you took out the door with you. But it's always surprising to me how people are pack rats like myself, and they have forwarded themselves communications all the while, whether it's to a personal email or they printed it out and they kept a copy, because there's always that voice in the back of your head of like, well, this, I kind of want to keep this. And you may not even realize everything that you've retained from your former job. So it's not just what you walked out the door with that day. If you were terminated because you were raising your hand about something wrong, it's really reflecting on your entire period of employment and thinking, well, there were those few instances where I printed that to cover my own tail. But now I'm realizing it's actually evidence of this problem.
Yeah, and you may have few documents. So we talk to all kinds of whistleblowers, ones who come with 1 million pages of stuff and they've documented everything, and others who, witnessed the fraud firsthand and don't have documents. And, the devil's in the details. And so you can't know until you talk to the whistleblower and evaluate what it is, what it is they know without documents. And if they do have documents, how helpful are the documents? So you can be a whistleblower with documents and without documents. And really, it really just does depend on your story. And we want to hear it, whether or not you have documents. But we will talk to you in detail about whatever and when we say documents, we don't mean hard copies necessarily, because nowadays it's Slack messages, text messages, emails, PowerPoint presentations, which a lot of companies and a lot of our clients have presentations.
Interestingly enough, I mean, because companies are getting smarter about how these cases are proven, you see more good evidence in informal exchanges like text messages and these other, informal applications like Slack or Google Chat than you do in emails, in traditional good old fashioned email is becoming old fashioned, I guess. It's kind of amazing. I still, I still hold close to email, but there's all of these other applications out there, and people are using those as their informal chat dialogue and just having conversation. And that's where sometimes you see some of the best evidence of fraud. Can you, yet another question, Renee, can you remain anonymous as a whistleblower?
Great question. And that is really a question that almost every whistleblower wants to know right up front. So when you get involved in a False Claims Act case, you need an attorney, first of all, and the attorney will file your case anonymously in court. It's called being under seal. So the court, unlike any other litigation that you file, where it is available on a public docket, if someone were really looking or using the Google machine to find, they could find. That is not true in the first instance of a False Claims Act whistleblower case. In fact, you are prohibited from doing anything other than filing it anonymously. What you need to do is, and again, this is something very important, you need an attorney who knows how to do this. You need to file the case in court under seal, which means you only go to court and the court seals it, does not put it on their electronic filing system for the public to see, as with all other cases. You serve a copy of your complaint to a prosecutor in the district where you are filing the case, and the prosecutor's office has a period of time, usually, a year or two if they need it, to investigate the case while the whole entire case is anonymous. And then at some point when the government makes a decision, whether the government's going to settle your case and get a recovery, or whether the government's going to intervene and litigate on your behalf, or if the government is going to decline the case, at that juncture, which is a long time into the investigation, the court will unseal the case and it will be available on the public docket if somebody's using the Google machine and looking for it. So eventually, for whistleblowers, you will someday not be anonymous, but during the course of the investigation, anonymity is actually required, and you are prohibited as the employee from telling anybody that you filed the key TAM case. You really need to just speak with your attorneys about the case during the government's investigation.
Mm-hmm. And that's under the False Claims Act. Under the SEC whistleblower program, you may be able to remain anonymous, ad infinitum, for forever.
Forever.
It that's kind of to some extent on you. The SEC does not publicize, frankly, much about their whistleblower rewards, other than, a general kind of press release that they are issuing an award. They do not identify what the award is attached to, which enforcement action it's attached to. There are people who actually specialize in being able to match this all up and identify whether an award is potentially linked to a recent SEC settlement announcement. But the SEC doesn't even announce a reward like the DOJ does in many instances with the False Claims Act attached to one of their enforcement actions. So you can't know when they're issuing whistleblower awards, whether that was a whistleblower in the Wells Fargo case or, any other recent announcement that they would have made. So there you can remain anonymous. But there are SEC whistleblowers who choose not to be. That's different.
Most of, I guess probably it's true that most of the financial reward whistleblower programs allow, the whistleblower to be permanently anonymous. It's really the False Claims Act that is different. But there are also whistleblower retaliation protections for before you file the case and after you file the case. So companies are, a little bit loath to retaliate against the whistleblower with the False Claims Act whistleblower provision. So again, these are all things that you need to really talk to your attorney about. It's a long conversation. You need to make sure the attorney addresses all your questions, tells you what the risks and the rewards are. And that's a decision that you need to make and balance, is this risk worth the potential reward that I'm going to receive if the case is successful? So let's see, we got a lot of questions here. So Eva, let's go back to if you work for a government contractor, and you have concerns, what types of concerns might you have about what your employer is doing that could potentially be a False Claims Act case? Can you talk about that a little bit?
Yeah, of course. Yeah. So some of the more significant cases that have been successfully enforced in the government contract space involve, for instance, selling bad parts to the military or selling bad products. So I earlier referenced the bulletproof vest cases. That was instances where the government was getting vests that were not bulletproof. Other instances for this are submarine, U.S. military and naval submarines that received components for the submarine that were defective, that didn't work as intended. And so you can only imagine the significance of those parts failing when they have a submarine full of military service members underwater. We're not talking about something as simple as, the verbiage isn't really just simply, I didn't get what I paid for. It's, I didn't get what I paid for, and that's now impacting and possibly endangering other people's lives. And you certainly see this in the healthcare context, but then you see more of it too in the DoD government contracting space. Other examples include just substandard parts or components or products, inflated prices, products that don't work as intended. So it looks like it's everything that the government intended it to be, but when they actually attempt to use it, and an easy example of that is more recently in the cybersecurity context, surveillance equipment that didn't work as intended. There was a recent press release about it, and basically the government learned that they paid millions of dollars, and it's typically millions, tens of millions of dollars for surveillance equipment that didn't work as intended. And as a result of that, that defective surveillance equipment posed a cybersecurity concern for the government. And as I'm sure many of our listeners are aware, cybersecurity is a big concern now, particularly with the Russian SolarWinds attacks and other types of cyber fraud that's not just happening within our borders. It's no longer that we just need to, fortify our physical geographic borders. We have to fortify the electronic networks that we all are using, and namely our government is using to engage in, really the biggest business in the United States with its multi-billion-dollar budget. So those are just a few examples.
So we're going to cover in a minute, Eva, you and I, let's talk about in a minute the cyber fraud initiative the DOJ has. But what I hear you saying is, as a summary, is if you work for a government contractor and you have concerns that your employer has not complied with contract terms, not complied with any government requirements, whether they're rules or statutes or regulations, or not use the government funds as intended, you could potentially have knowledge of a False Claims Act case. Does that sound right?
That's exactly right. That's
Okay.
it. Yeah.
That's it. Well, the other thing, yeah, you go ahead.
No, go ahead. We're always interrupting one another.
That's part of our charm, I think.
That is part of it. We never get annoyed about it. We both have good things to say, but we spend most of our week listening, I should say. We spend most of our week listening to potential clients in developing cases. So this is our one forum to get it all out.
That is true. We are in listening mode most of the week. So one thing that we think is really interesting is the DOJ's new False Claims Act, Civil Fraud, cyber fraud initiative. And what we think is so interesting about it is DOJ often has initiatives. So when I was at DOJ, I headed up the financial fraud initiative after the big financial crisis. And we investigated and litigated against most major banks for bad mortgages, put simply. And that was a huge initiative. Eva worked on the big pharma initiative that DOJ had for a number of years, involving anti-kickback schemes and what's called off-label marketing. And there's often all kinds of initiatives that DOJ has, which is really all that means is they put a lot of focus, money, resources, efforts on that particular area, because at that particular time, like after the financial crisis, where there really was an effort to hold banks accountable and also to recover misspent federal dollars in different housing insurance programs. And frankly, in that financial initiative, it was really an effort to make sure that the Mutual Mortgage Insurance Fund was solvent, because for the first time in history, it was at risk of insolvency. So there's been initiatives before, but this is the first time that Eva and I have ever seen DOJ start an initiative and put out a huge call for whistleblowers. It's just not something simply that they do. Of course, they often are driven by whistleblower cases, but in this instance, in October of last year, so really just a few months ago, DOJ made several press announcements and has been very vocal. And in fact, one of the assistant directors here at Maine Justice spoke on a podcast about cyber fraud. And so they are, I've posted something on LinkedIn with a picture of Uncle Sam saying Uncle Sam wants you. And that's exactly what DOJ is out there doing. They are talking it up. They are looking for people who work in the government contracting space, particularly, who are aware of cybersecurity violations. And there's sort of two big sort of buckets the way that I see it. One is if anyone who works for a company that has a cybersecurity government contract. In other words, that is the purpose of the government contract, to provide cybersecurity protections for the government. They are interested and want whistleblowers to come out of the woodwork and report that their employer either knew that they weren't complying with those contract terms or weren't complying with other government regulatory requirements. And there are many cybersecurity requirements. And I recently spoke on a panel with 3 other attorneys, and we got deep in the weeds on what those new cybersecurity requirements are. or if they took the money for cybersecurity protections and did not use the funds as intended. That is one bucket, but a whole other bucket, which is much broader, is many government contracts require cybersecurity protection of the government information. So in other words, every single contract does not always involve a contract for cybersecurity protection, but there are implicit in many of the contracts that you're going to have government data. If you're contracting with the government, you are probably even sitting in a government facility working side by side with somebody at the Pentagon, or you are given access to government information because it's part of what you're doing as part of the contract. And of course, you are required to ensure that while you have government information or whatever project you are working on for the government, that you have good cybersecurity protections in place. If you violate any of those cybersecurity rules, which are part of most government contracts now, you can also be liable under the False Claims Act. And so this is a big initiative. And what does that mean, Eva, when they have a cyber fraud initiative? Like if you're a whistleblower and you have that kind of inside information, what can you expect if you go knocking on DOJ's
You go
door?
to the top of the pile. You go to the top of the pile using, famous words. You literally, you are the primary case on that DOJ line attorney's desk. They've cleared everything else off. And we are aware, and we're aware of this from the podcast that Renee was just speaking of, that the DOJ has a committed unit. They have a committed assistant director and committed other persons who are going to prioritize investigating and enforcing cybersecurity violations. So again, it's a bit unprecedented, but in terms of DOJ initiatives, whether internal or externally announced, you can assume that your case is going to get the attention that it needs in real time. And that speaks volumes. Because when you think about these whistleblower programs, there are hundreds of cases that are being filed every year, and there's already a docket of hundreds and hundreds and hundreds of cases that are live and outstanding. And so to the extent that there is any way for your particular case, and here being a cybersecurity case, and just to break that down briefly, when we're talking cybersecurity, just as Renee said, it's not just about companies that provide security services. It's really the protection of any and all information that you're handling on behalf of the government, most of which now is being stored electronically. And so even health records now are being required to be stored in what's known as an electronic health record, or EHR format. So there are a number of vendors that have popped up, and they're significant vendors, they're big vendors, they're sophisticated vendors who are transitioning health records to an electronic format. In the government contracting space, most of that work is now being done and has been done electronically. And so then the question becomes, what is that government contractor doing to protect that information that's on an electronic network? And how are they keeping that information confidential and secure? And what we're seeing in this space is it's a combination of things. On the one hand, it can be a deficient cybersecurity system, basically. The system has flaws and deficiencies in it. Easy example, if you can log into your computer without a password at work, kind of a obvious, like, wait a minute, anybody could access my desktop and access the information that's stored there. That would be a deficient cybersecurity protection for government information. Another way to think of it is misrepresentations of their cybersecurity sophistication. So government contractors are now being required to represent to the government before they're awarded any kind of a contract, whether it's building submarine parts or providing national security services or manufacturing bulletproof vests. They're required to make certain representations to the government that they have the necessary cybersecurity infrastructure. They have allocated the necessary money and personnel and resources, and will spend the necessary time to provide those protections. And if they make a misrepresentation about their capabilities in that regard, that could rise to a False Claims Act violation. And in fact, that's what the Deputy Attorney General specifically called out as a possible False Claims Act violation. The final one, and this actually applies to everything we've been talking about, and it goes back to what Renee said about whistleblowers who may be aware of fraud, but they walk away and don't say anything. If a company is aware that they're doing something wrong and they fail to do anything to correct it, that also can rise to a False Claims Act violation, because they're actually, it's called a reverse false claim, and not to get too technical, but they're holding on to government funds that they're otherwise, they know they're not entitled to because they can't perform on the contract, or they can't provide the service or the product that they promised the government that they would provide. So there's so many different layers, which again brings us full circle back to, it is why there's a lot of efficiencies, frankly, and importance in seeking False Claims Act and other whistleblower program expertise from an attorney. If and when you come upon this type of information, whether you're in a company, you're working with a company, you're observing practices just in the industry, that's I think really the number one step of gathering your documentation and then having a conversation.
Yeah, and I mean, these are great points, Eva. And then, you know, another person asked a great question on follow-on, like, how long does this whistleblower case take from start to finish? And I love this question, and I think it segues from exactly what you were just saying, because there's a lot of factors that really go into answering that question. But one thing that Eva and I very much so believe, and we believe this because we were wearing the government's hat, we were in the prosecutor seat for most of our career. So we know that the whistleblower team that helps the government the most get the case over the line and assist the government with the investigation will, you know, be able to expedite the investigation, basically. So you can't control for every single variable, but the more time and effort that you, the whistleblower team, and when I say team, I mean, for me and Eva, our team is Eva and I, our whistleblower or whistleblowers. Sometimes we have more than one. We have a phenomenal staff, including Emma Schilp, who is our paralegal and who knows this space really well and works very closely with our team, is a big part of our team in helping the government to investigate its case more expeditiously. And we often have another attorney at our firm, and sometimes we even have co-counsel. So a lot of times whistleblowers come to us because an attorney who's not a specialist in the False Claims Act, like as I said earlier, you know, maybe they're an IRS expert, or they do employment law, or they do something that is not specifically in our space, and they bring the client to us. And so we usually have a really large and strong team that helps us with our investigation, and we help the government every single step of the way. We are side by side with the prosecutor during the entire investigation. And so that means everything. We assist the government with all of its investigative tasks. They usually look to us. Eva and I have different expertise. Eva was the senior counsel for healthcare fraud at the Department of Justice. So she really deeply understands the healthcare space, and she knows how to analyze Medicare and Medicaid claims data to look for the fraud scheme. So prosecutors very often turn to Eva for that kind of assistance if they don't have deep experience in data analysis. And
Renee oversaw more subject areas in the fraud context than anyone else I know, really. She pretty much worked with every single federal agency that was a client of the Department of Justice because of False Claims Act allegations. So
between us, we do really have, have a lot of, past experience in this space. So you can get to the end of the line sooner if you have a team that is going to work side by side with the Department of Justice, helping them with all their tasks. Because many of these cases are staffed by one prosecutor, sometimes two, sometimes they have a paralegal. None of them have an Emma Schilp
True. And
None of
they
them.
never will, because we're not letting her go.
They will never have that kind of a paralegal, but they will have some assistance in their office, but they are very benefited by having a team with the relator, what I call a relator team. And I probably should have said a relator is a whistleblower. It's just the formal term that the False Claims Act refers to as a whistleblower is a relator. And so that is going to dictate in part how strong your team is, how long the case will take from start to finish. Because if the prosecutor knows that they have a good team, someone that's really going to assist them and help them do all the tasks that they need to get to the end of the case, to the end of the investigation, your case is going to move faster. Shy of that, there are just a lot of factors, including the cooperation of the company that's under investigation, which is something that, we can't control. And there are some other variables like the court, what kind of deadline does the court impose on the team? So those are factors that will come into play. So it's very difficult, if not impossible, for us to say how long a case will take from start to finish. But we do always guarantee that we will do everything we can in our team's power to assist the case with getting moved along as quickly as it can. So I think that was, yeah.
We're rounded out. It's the top of the hour, Renee.
Oh my goodness, we are done.
Yes.
We are grateful that you joined us today on office hours with me and Eva. And we are going to be having this kind of conversation on a monthly basis. And I think Q's going to jump in here and say when our next time will be.
Our next time will be on Thursday, May 5th at 3 p.m. Eastern, 12 p.m. Pacific. So stay tuned at fraudfighters.net/office hours for both the recording and information about how to join the next session.
Great. Thank you, Q.
Thank you.
Thank you,
Hey,
everyone.
Renee. Talk to you in a bit.
Talk to you soon, Eva.
Bye.